afternoon, everyone, and welcome once again. We're really excited to have you here at the KoreSummit Webinar Series for FINRA broker-dealers, funding platforms, and marketplace. Today, we have a great panel discussion with Mitch and Marty that were here last week. We'll get that. But first, I want to thank our sponsors. Without them, today would not be possible. First of all, Nuvei. If you're not aware, Nuvei is a publicly traded company in NASDAQ. It's a leading fintech company providing payment solutions around the world. In fact, 160 plus countries around the world, working with companies in the private capital markets and, of course, outside of that, e-commerce. And, of course, KoreConX, the first all-in-one platform providing compliance technology services both and for the FINRA broker-dealers funding platforms. So today, we're really excited, once again, to bring our guests back, Marty Tate. But, you know, just for everybody that's new, they may not know it, who you guys are. So, Marty, if you could take a minute to introduce yourself, and then Mitch will go into you. And then we're going to dive into our great discussion today. We're going to talk about RegA and all that is required to be met by the broker-dealers, funding platform, and marketplaces. So, but let's start with introductions first.
Yeah, it's nice to be here. Marty Tate. I'm a securities lawyer based out of Salt Lake City, Utah. I've been practicing for going on 25 years, all in public and private finance. I also work with, I've been involved with crowdfunding and the Jobs Act since the very beginning. I work with issuers, platforms, funding portals, service providers, broker dealers in this space, and yeah, happy to be here.
Mitch.
Great. Thanks so much for having me. My name is Mitch Avnet. I am the founder and managing partner of Compliance Risk Concepts. We are a compliance services firm headquartered in New York City, focused on the broker dealer and asset management space. I've been in the industry for 31 years now, and most of my compliance experience is around capital raising, investment banking. And so these subjects and topics are very near and dear to me, as we do help a lot of broker dealers and funding platforms who are in this space. So thanks so much for having me.
Oh, guys, we are going to have a fun discussion today. The last one was fun. It was a little bit more tricky because it was Reg CF and with so many different models. And again, our whole thesis in everything we're doing today is we are really trying to help the ecosystem of broker dealers, funding platforms to do things compliantly. But today I started a conversation with Mitch that I think only a very small piece of the market got to read. And I'm not sure, Marty, you got to see this article. So recently at the New York Bar Association in New York, the SEC Division Enforcement Director, Gurveer Grewal, has put it out on notice that, you know, the SEC will issue charges against compliance officers. Being a compliance officer does not mean you get out of jail card. You know, as it's been, some might think of it that way. So this is really important, in particular, the things we're going to discuss today, that it just goes to illustrate that everyone is now paying attention to compliance. And more importantly, before we only discussed it from a firm level, but what this director has indicated is that he is now indicating that we're coming at the individual level. I'd like to take your take on this, Mitch, because, you know, before you got started, I asked you your background. You've got 20 plus years experience as a compliance officer. So let's just talk about that for a bit. We're going to move into the RegA, but I really need to talk into this because I have some experience I want to talk to you guys about, but I want to hear yours first. What do you feel about that message that's being said by the SEC?
Yeah, you know, so listen, I was an in-house chief compliance officer for about 13 years. And our firm provides outsourced chief compliance officer support to our clients today. You know, while those remarks are geared as, let's call them, a wake-up call, for lack of a better term, it's a real risk that I think I always felt, and other CCOs that I communicate with always felt, at the end of the day, I've never felt like I wasn't on the hook. The problem you have, especially in many organizations, is there aren't clear lines of delineation between compliance and supervision, and roles and responsibilities get muddled. Okay. And I think, if anything, there really does need to continue to be a clear delineation between front office supervision and the role of a compliance department and a chief compliance officer, and really staying in their lane, so to speak, so that they can ensure that they're doing everything they can do. Let's call it from a second line of defense perspective, where, as it pertains to the firm's, business sales practices, how they approach the various business lines they're in, and ensuring they have the appropriate compliance programs and controls in place for those businesses. Where I think compliance officers get in trouble is where the lines get muddled and they become complicit in certain activities just by the nature of how the organization is structured, or may have lack of structure. And this is a problem, especially in smaller organizations, where it's not as easy to delineate roles because there's only so many people, and who's going to do it. Having said that, you really have to be careful, thoughtful, and pragmatic in terms of ensuring you have the right written supervisory procedures, that you're adhering to them, that to the extent that there are new products and services, you understand the risks and the operational infrastructure that's going to be required to go along with it. And the thing I've been saying forever is, at the end of the day, don't get involved in one-offs. Unless you have the capabilities built and you have the program in place to execute and scale, doing something as a one-off is a road to problems, and it leads to operational issues, which will lead to compliance issues, and then you're going to be on the hook. So the long and the short of it is, Oscar, I think this, I've always viewed this as a real risk in terms of my own personal liability. It's really up to everyone who does this job for a living to really understand how they manage the risk out of that around being a CCO and the liability that comes along with it.
Yeah, you're right. I mean, when it comes to individuals like yourself who take it seriously, this is your life, this is your profession. Before I give an answer, Marty, I'm not sure if this message, what I provided here to get us started, you had heard about it or read about it. I mean, have you come across, I know we can't disclose names or anything, but where you're seeing where it's not just a firm, but the actual CCO is being the one that they're reviewing their practices and how they're engaging their job duties as their chief compliance officer for the firm?
Other than what you just mentioned, no, I haven't seen that, but that seems like a I don't know. On the one hand, I think that makes sense. On the other hand, that's scary. And if you're hiring a chief compliance officer who knows that they could be facing possible, civil or criminal liability in that role, that might make it difficult to find a chief compliance officer.
Well, a minute. Well, again, maybe that the increased risk profile really drives the price or the cost of bringing on a CCO ultimately, because who's going to sign up for that, especially if there are clear and present cases out there where you see the SEC going after CCOs. The other thing to keep in mind is, let's just say, even if it's a slap on the wrist and you got caught up because there was a breakdown in the part of your supervisory system and the CCO is named. The thing that really troubles me on that front, and always has, is if that goes on your U4, especially in this day and age, that's going to stand in the way of your ability to get hired to do that job again and again. So again, I keep coming back to it. Like, as alarming as it sounds, I guess being in this industry for 30 years, it's not surprising to me. I just think, you can't take the role lightly. You can't trust that things are getting done because people are good people. You have to trust but verify, and you have to have the programs in place and be able to back that up, whether it's in an examination, an investigation, and be able to go toe to toe in defending your program.
Great messaging, and this leads us directly to the next point, the next part of our discussion we got together. And people will go, well, how can those two relate? Well, they can relate because this year in 2023 was 2023 was the year of subpoenas. This was the year of subpoenas. Now, they might have not been directly looking at the broker dealers and the activities of all of them or their CCOs, but I think what we all need to recognize that here we've been given this gift to raise capital using these regulations, and we use these intermediaries, and they're important one being a broker dealer or a funding platform. There's a regulated person who needs to truly understand that, and more importantly, the consequences associated. So today we're going to discuss that, because I have to tell you, I struggle sometimes. I call Marty. I go, Marty, what can I tell this person to get it through their head? And I kid you not, I often wonder, you go through all that process of getting the certification and all this, and sometimes it just, for me, it's staggering to see that we still have a way to go to educate. So this is part of what we're doing here today. Even though people like yourself, Mitch, it's embedded and in your mind, you got to do it in a lot of your colleagues. We have to face the fact there's newcomers coming into the profession. That's number one. Number two, there are people who may not know and then realize, oh my God, there is a consequence. Let's assume that. I know it's kind of hard to assume that, but I've learned that a lot of people assume a lot of different things. So therefore, with that assumption, we need to make sure that we're continuously educating the market and making sure that everyone has a clear understanding on what it is that they need to get done. And I think today the discussion we're going to have, in particular with RegA and FINRA broker dealers and funding platforms, we're going to start right there from the broker dealer perspective. Marty, let's just get started here in one area that this has been a bit of their role. Let's just talk about that role that is defined when a broker dealer is now handling, doing a RegA with an issuer that's been qualified and so on. And because there's a lot of misconceptions here regarding what that role specifically is. And then we can start talking about the specific duties. Can you touch on that?
Yeah, so I think that, we talked last time about the roles of a broker-dealer in a Reg CF offering. And with regards to Reg A, there's a lot less, it's Reg CF is very specific on this role of the funding portal and what they can and can't do. And if a broker-dealer is playing that role, they've got to comply with those rules. They've got notice requirements. They've got communication. They've got a lot of things that that they need to do in order to comply with Reg CF. Under Reg A, the requirements, you don't have all of those requirements. That doesn't mean there aren't things that a broker-dealer needs to do, but a broker-dealer that is conducting Regulation A offerings, they're going to fall under a different set of rules. Are going to fall under the FINRA rules with regards to what they can and can't do. And again, there's not the same notice requirements. There's not the requirements of communication channels. There's a lot of those rules that are set forth in Reg CF are not there. And we can expand on that, but I think that's, what we'll talk about today is really just the contrast. Now, one of the things that we'll have to consider as we talk about this is a lot of people will be doing, trying on their platform to be doing both, or all three, meaning they're trying to do Reg CF, they're trying to do Reg Ds, and they're trying to do Reg As. And so that the challenge for that chief compliance officer is to make sure that each of these offerings is complying with the different rules that apply to that offering.
Agreed. But one of the, but just to make sure, Mitch, maybe you can help as well here, but that is that when a broker dealer is engaged in other regulations, they're required to undertake a number of activities. But one of the things that, at least it's been framed, is where they are the broker dealer of record, which means that they're not providing advice to investors. They're not onboarding that investor into their firm. They're simply providing the service of compliance. Mitch, could you touch on that with Regulation A+?
So I do want to touch on one thing that you said first before we go into that, because it is all connected at the end of the day. But you made a comment, Oscar, that there are a lot of people that you deal with who may be on this call as well, who are new to the game, right? And don't have the history, the perspective, the industry knowledge of how to set this up and actually implement and do this. And the one thing I do want to point out, because I do work with many fintechs who are broker dealers, and it's really important up front to work with the right service providers, whether it's outside counsel, whether it's a compliance provider, whether it's good technology partners, because you may feel the pain of having to do all of that up front, but at the end of the day, again, it'll be much easier to build those aspects into your program up front than to try to reverse engineer what you've built if compliance and anything from a technology perspective, anything from a legal perspective were an afterthought. Okay, so always better to feel that pain up front and surround yourself with those who have done this and have done it well for others and can share their knowledge and their experience and their expertise with you. And so, I think your question, Oscar, is a good one, but truth be told, in all the clients that we work with, it's not all that common that I have clients that just do Reg A or Reg A plus deals. Most often they're doing Reg Ds, and this is another flavor, so to speak, in terms of what they can do in terms of capital raising. So from my perspective, and we talked about this last week on the other call, I'm a big fan that if you're a broker dealer and you have more stringent requirements than the regulation may tell you what you need, whether it's a Reg CF deal or a Reg A deal, I tend to err on the side of being conservative and going full-fledged across the board. Having said that, that doesn't mean I'm right. That means from a risk management standpoint, I want consistent and cohesive processes that if anyone were to point to me, I'd rather them tell me I'm doing too much versus too little, okay? And we can argue if anyone who's subscribing to one of these deals is a client. Some people may say they are clients. Some regulators may say, well, for all intents and purposes, even though they're not opening up an account with the broker dealer, you're still servicing them as a client in one respect or another. We can argue that point. But what I tend to do in the programs that I've built and we built today for our clients is we want to build best in class so that they're not just tied to doing it, this very pigeonholed sort of approach for Reg CF, this pigeonholed approach for Reg A, and then what they do for Reg D, and then, of course, registered deals for that matter. So having said that, one of the things I highly recommend and what we do for a lot of our clients is we build them a grid, okay? And in that grid, we put everything under Reg D that you're required to do, 504, 505, 506, and what the nuances are in between each of those types of offerings. We do the same thing for Reg A, Reg A plus deals. We do the same thing for Reg CF. So you have it right in front of you, so you know how you want to go to market, who your ultimate audience is going to be, and in terms of what you're trying to do, what makes the most sense in terms of your capital raise.
It's, I like that. Great idea, because it is true. You have to be agile, but you also need to make a decision as a firm how you operate, but you need to have that laid out in advance. That way you follow it through on each of the different types of raises. You can't, because I'm reading some of the directors' fines, and it's interesting that even though the policies and procedures were in place, certain members were not following the steps. So it's not just having the grid, it's also following it and make sure on every deal you always do the same thing. So if you're going to be collecting, I know it's going to sound funny, so don't laugh, but if it says I'm going to collect the social security number on every investor on the next deal, you do it as well. You don't just decide randomly, no, on this deal we're not going to do that. So but thank you for that, because it is it's not, even though the regulation has flexibility, I'll use that word, or has different requirements, but you need to be consistent in how you follow it through for each one of them.
Absolutely. And if you look at RegA, like the KYC from a RegA perspective doesn't truly align to what KYC means from a Reg D perspective, right? Because there's different levels of an onus on you as the broker dealer. Okay. But the other thing I want to say is another good idea. Again, we do this across all our clients as well, is once we draft WSPs, because we do a lot of that kind of work, what we automatically do is we attach a compliance calendar to those WSPs, which completely reconciles to all the who, what, when, where, why, and how often that it calls out in the WSPs. So it, again, right in front of you, day to day, week to week, month to month, quarter to quarter, you know what needs to be done and who needs to be accountable for it.
No, that's a pretty effective way to approach it. And I just, it's good. Like you said, it's good as a reminder for everybody that's coming on this call. And we're going to touch on it because you brought it up. And from a comparables perspective, you brought up KYC difference between Reg CF and Reg D. But last week we spoke about Reg CF. So not only do you need to have the chart on how you're going to do KYC, but you also need to understand the differences in your responsibilities for each one. Because there's a responsibility, right? So there's a responsibility on Reg D, the undertakings you need to take. For Reg CF, the undertakings that you need to undertake that are beyond just this particular deal. And then Reg A as well. And so I think those are an important element. So I normally call these the attestation requirement, but it's really making sure that the broker dealers have the knowledge set to understand, yes, you can do it, but please make sure that when you do, you have the knowledge and understanding and put the processes in place to make sure that you are consistent on how you're doing it. So in KYC, let's talk a little bit about that. We talked about the Reg CF. So I don't know, Marty, do you know the regulation? I think you do. So let's talk a little. I'm just joking.
Come on, Marty.
I'm just putting a little humor. It's Wednesday, It looks like you're getting snow where you are and you're going to be going skiing, and I'm jealous. So, but let's talk about the KYC requirements under Regulation 8, because there is something uniquely different between that and Reg CF and Reg D, and that is where when the investor's coming in from the ID and AML not, but there's a suitability component to it. Let's just talk about that, what the responsibility is from the broker-dealer, or forget the broker-dealer, the compliance officer that fits into this model.
Yeah, so, well, yeah, I guess then that those are different, right? The compliance officer and the broker-dealer are going to have different, one's like, so I'm going to look at it from the broker-dealer perspective, but I think it translates across is, as a broker-dealer, it's, and again, this is where all of this is very nuanced, because with a private, there's rules that apply to private placements under Reg D, and there's rules that apply to public offerings, which RegA under Rule 5110 is considered a public offering, although it's an exemption from registration for SEC purposes under RegA. But with respect to that, each broker-dealer is required to follow KYC or CIP, customer identity. They're required to have a customer identification program, which basically, allows them to know who the client is, and understand, and that applies to these investors that are coming into the offering. So what does that mean? For all intents and purposes, it just require, they're required to verify that this person is who they say they are. They're required to get, identification for that person. They're required to get, again, name, address, social security number. The more information, obviously, the better. They're required to get a copy of, or they should get a copy of their passport or their driver's license. So they're verifying that they know who this person are. Then you talk about suitability. Suitability requirements means, is this investment suitable for this type of investor? Now, RegA has some built-in suitability standards kind of built in, which is accredited investors can invest whatever they want, and there's no limit on the amount that an accredited investor can invest. Non-accredited investors have similar caps on the amount that they can invest based upon their income and net worth. So that, suitability requirement, I guess, could be taken care of just by making sure that the broker-dealer, making sure that those investors are, if they're accredited, that they, again, they're allowed to invest whatever they want. If they're not accredited, then as long as they're complying with those limits, then it would be deemed that the investment is suitable for them. And so that's kind of the base level on a RegA of what would be required.
Okay,
Mitch, do you have anything to add? I'm looking at Mitch's responses. I talk, and if he shakes his head, I know I'm saying the right thing. And if he starts doing this, then I'm like, I'm saying something.
No. I think you said it perfectly, because the way I look at RegA deals, it's really more on the KYC CIP standpoint. It's really more centered around investor eligibility, and it doesn't go as far as what you would see in a traditional KYC CIP type of review that's focused on traditional money laundering, right? And so it's really centered around eligibility. And I think we're saying it the same, maybe different words, but saying the same thing.
Yeah, and you brought up something that I don't know if I fully want to go into, but you touched it. But that sort of AML, right, which is you get the money laundering, and people ask that. So, are we required to do AML on our investors? And again, this goes to, again, there's a broker dealer, there's the broker dealers that ask this, and then there's the issuer that asks it, because these investors are going to be coming into the issuer, and I guess it's how you want to assign that risk. But there's not a standard, like, right. Yes, you have to do it on everybody. And typically what I've suggested is, you set a dollar amount, like, hey, anybody that's investing more than $10,000, it's prudent to do AML on them. Again, it's not required, but again, this is more.
Well, but that's where I want to stop. Yeah. This is where I'm going to come in, because we've been having this argument. Well, not you and I, but I brought this to you, where we know there are lawyers telling RegA issuers, you don't need to do any ID and AML, and if it's not over this limit, you as a company have a pass from the SEC. So, everybody's only looking at this part, but what they're not looking at is they're not looking at the entire flow of this transaction.
Yeah.
That's
and
the
we've talked
important thing. You need to
about
look.
this, Oscar, and I was
Yeah.
going to go there. I was going to go there because I know this is a hot point.
Please continue.
Well,
No, you go ahead. You go ahead.
Before both of you hash this out, I just want to put with a little bit of emphasis because it's very timely to this conversation. And again, just from a comparison, you're contrasting or analogizing, whatever you want to call it. I talk to clients all the time who are not at the point based on their business model. Again, mostly fintechs, that they don't need to register as a broker dealer today. Okay. They may be doing things that look like and feel like they're going to need to register as a broker dealer, and they need to understand where the line is, right? But I will tell you, 10 times out of 10, even though they don't have the requirement in the technology stack that they're building, they have the AML KYC already built in. So even though they're not required to by regulation or law, I think it's just embedded in everybody now that nobody's going to deal with you unless you have this.
And I want Marty to, because you know what, Marty, you're the lawyer, and I want people to hear from Marty because there's an extension, and I'm gonna give it a layup to Marty.
Yeah.
There's an extension. You're 100% correct, Mitch, to what you just said at this phase. But the transaction has two other phases. Marty?
Yeah, and so what, again, so going back to the point, right? You're technically not required to get it up front. It's advisable and prudent to get it if they're over some dollar amount. That being said, if you plan on any sort of secondary market, any sort of subsequent transactions, that piece is going to come into place, right? So that requirement is suddenly going to come up to say, what AML have you done? Especially as you enter some of these, again, with regards to the secondary transactions, that information now becomes a necessity. Is that the layup that you were looking for, Oscar?
Actually, that's one of them.
Okay.
So if you don't mind, I'll up the second one. The second one is, even before secondary, where does that money need to go? To a bank.
Yeah.
To a bank. And here is the mistake the banks made since 2012 till 2023. They assumed because they heard Mitch one day on a panel, I'm just picking on you, Mitch, saying that, oh yeah, we conduct the highest level because that's the standard. And they go, well, hey, if they're all doing what Mitch is doing, then Mitch is doing exactly what we need him to do. But then the reality is that the broker dealers or the funding platform were doing the most basic of all. There was a time, if you can believe it, funding platforms were not even collecting date of birth when people were making investments. How on earth can you be taking money? So why is that important? Because 2023 was the year that we saw the financial collapse of the back end of our private sector, meaning that the very few providers we had were either shut down, filing for bankruptcy because they were failure for AML. And so now when people say, I always agree with them, you're right, your lawyer advised you correctly, that is all you need here. But because the money needs to go from here to this account where you are required to hold the money, the bank is saying, no, we need ID, AML, driver's license, or passport, and we need that information before the money lands on the bank account, or we're not taking the money in. So you're right. You don't need it in this end, but you need to look at the transaction completely. And then, of course, if there's an SEC transfer agent, then we have other, and then secondary market just adds to it. So you're right. I agree with everyone. And just, I like what Mitch said earlier. I think I'm going to use that terminology. We're going to give people a grid. You're right. From a broker dealer, you just need this. But the reality is, in order for this transaction to close, it needs to go from a payment processor to an escrow bank with an SEC transfer agent. So therefore, guess what? It needs A, B, C, D, E, F, G, and you have to collect it here.
And right? A lot of that, Oscar, is, I think you said it right. We've seen that become an issue recently. That wasn't an issue initially. A lot of times, a lot of the cases, because people were using trust companies as their
Right.
escrow, and they weren't using banks, right? But now we're seeing, that's generally gone away, and you're seeing really these escrow being handled by banks. And again, they want to know, they need to know that information. So you have to have all of that information there.
Exactly. It's a mandatory, like this year was an awakening. The banks that I'm dealing with, they would use words like, and I kid you not, I won't mention their name, but they would write to me, Oscar, we assumed. I'm like, wow, this is but I get it. I think I understand how it happens, because we see the title chief compliance officer and we see the rules and we go, everybody's applying it the same way. But we now know that people will apply whatever they feel is necessary, and that's it. And then there are times where we see issuers taking advice from certain lawyers out there, who are lawyers are even telling them, you don't need to do that. Don't worry about that. Yeah, you don't need to add that extra burden of cost to you. But it's, now we've gone the other way, which is, so I think it's a good reminder that, once again, that for whatever regulation, in particular in RegA, it's not to look at the activities that you need to undertake from a KYC perspective, is to make sure you follow the money. Because, so why is this important, broker dealers and everyone? You want to get paid. If the money doesn't land on escrow and you can't clear it, you can't get paid. So, if the motivation is to get this done as quickly as possible, here it is.
It's really interesting. Sorry, I just want to chime in here because
no, it's okay.
We work with a lot of clients who are filing for new membership applications with FINRA to become broker dealers, or FP NMAs to become funding portals. And they have to demo their technology as part of the membership process, okay? Whether it's proprietary or they're relying on you, Oscar, okay? And so, but the long and the short of it is, MAP has gotten very good over the last several years at really determining where the issues are, because they will look at the end-to-end process of what's feeding what, and really want to know how your processes address all of those things. Even though the regulation may or may not tell you have to do something, commercially speaking, you're not going to be able to clear settle your transaction and get paid, to your point, unless you meet the standards of your service providers. So there's the regulatory aspects of it, which again are front and center, but there's this commercial aspect of who you're going to work with and who's going to support you in doing the business that you want to do. And you're not going to get it done unless you meet their standard.
That's great. And that leads into another element, that if it's all done, if the companies understand, or the broker dealers getting involved, and obviously what are they doing this for? They want to help a company raise capital. Okay, great. And capital is coming in different ways. The only way that we've been talking till now, the KYC, is the investor coming directly to the site, entering their details and all that. But there's a whole other world out there, the registered investment advisors and so on. And those participants would love to participate, but they need the confidence level. So coming back to that whole thing of trust. So I think we're all saying the same thing. I think I know we're reminding everyone that when you look into this, and you said it really interesting, Mitch, don't treat it like a one-off. Don't just bring it in as a one-off and just do it, because you don't get a pass on not doing all the other things.
No, and it's listen, it's a tale as old as time. Okay, I'm not that smart. I've just done this for a long time. So the long and the short of it is, if you have an opportunity as a broker dealer or a funding platform, whatever, and it just appears on your lap and you have no infrastructure to do this, you shouldn't be doing it. Okay. And the first question you should be asking yourself is, why am I so lucky that this landed in my lap? And again, that's the CCO mindset in me. Like, follow the money. Why are they coming to me when they could have gone to anyone else on the street? Because everybody else turned them down.
Yeah, that's interesting. I like that. Why they came to me. All right. So we've obviously the undertaking of the KYC is a big component of it, but let's talk about the other. So that's from the investor side, and let's talk about the issuer side now. Onboarding a broker dealer or a funding platform, onboarding an issuer from a due diligence requirement, because the issuer is going through a massive undertaking, filing a Form 1A with the SEC. So what more does the broker dealer need to do, or does the broker dealer need to do any more on that, Marty?
With regards to issuer due diligence, is that what you're saying?
Correct.
Yeah.
Yes,
So the broker dealer should do, again, full bad actor checks on the company, the issuer, and its principals, because if they don't, they could be disqualified from being eligible to use RegA. And they should do. The broker dealer would be wise to do financial checks on the company. The broker dealer really should also be really involved in the 1A process. One of the things that's really frustrating is working with a handful of these broker dealers that are doing RegA, and they are just, they're they might be on our distribution list, and they're not reviewing the RegA, they're not responding. And then we get to this process. And one of the things that's just, I'm going to get on a soapbox, but it's been bugging me lately.
No, it's been bugging me. You brought it up.
The number of these broker dealers is that they're not participating. They've got to be working on the Form 5110. They should be active in the process the whole time. And a lot of times they're not. They're just kind of sitting by. They're just waiting. And then all of a sudden we clear comments with the SEC, and they're like, oh, I guess, yeah, we should file that 5110. And now we're 3 months now, and we're having to make additional updates because the FINRA comes back and says, hey, change your 1A, the use of proceeds section, right, or do this or do that. And we could have been doing this all along. And so the broker dealers, this isn't the diligence issue, but this is just get involved. We need to be working together on this process. I think a lot of them, especially the broker dealers that are being more of a just broker dealer of record, where it's like, hey, you're listing X broker dealer on the 1A. They're like, hey, we're getting our whatever 1%, and we're just kind of named here, but we're not really doing anything. That's not true. You're still the broker dealer of record. You still have to be involved in the process.
Thank you so much for saying that. I don't know how I was going to bring it in, but you did. And I think that's we've been talking about all the engagement from a KYC perspective, but we're even talking even before the deal gets started. Yes, you're the broker dealer record, but you got to be engaged. This year was all the BDs that just kind of waited till the last minute created a massive roadblock at FINRA getting qualified, so they can go live. But the engagement has to be there. I think what I personally see is a lot of them don't even pay attention what's in that document. I sometimes go into it just out of curiosity, just to see, have you paid attention to what is being that? Are you paying attention who is actually the selling shareholders? You need to be aware of this, because this could be a backlash to your firm. There's a broker dealer right now that's taking a lot of backlash in social media because apparently, they didn't do their due diligence, and they did their bad actor and all that. But in the filings, there was information about where the money was going to. The money was going to pay off the founders. So you got to be ready, whether you're a broker dealer record or not, that the market is going to say, you're the broker dealer. You're the one that hanged the shingle that said, hey, I helped this company raise $50 million. You take on that responsibility. So I agree with you, Marty. Engagement is important. You're responsible for it, whether you're just a broker dealer record. Love to hear your comments on that, Mitch. I mean, we've seen it just from the operational side.
Unfortunately, I'm going to keep saying the same stuff. So
it's okay.
Listen, due diligence is one of the, as far as it from a FINRA examination standpoint, I could tell you this, it's low hanging fruit. Okay. Like all the notices are out there. Like firms have everything at their disposal in terms of FINRA expectations, in terms of how they should be conducting due diligence, regardless of the type of deal. Okay. And so to me, again, it's about having that consistent process across the board. And where I see companies, mess up is there's inconsistency. This file has these documents, this file has those documents, that file has no documents. And, it's one of those things where you have to create the process and you have to adhere to it. And while all due diligence is not created equal, because there might be some things that are not applicable to the issuance or the issuer, document that. Okay. And so to me, it's all around careful, thoughtful documentation and a consistent, cohesive approach. And again, come back down to create the checklist. Have the checklist at your disposal for the type of deal that you're doing. Run through that checklist. Make sure you have, and again, I'll say this, Marty, I hope you'll back me up from a legal perspective or a litigation perspective. Have no more nor no less than what you need in that due diligence file. Okay.
Perfect. Yeah.
Yes, I agree.
I agree. I'm 100% with you there. I think that's it's when you start deviating from one deal to the other, that's when you start putting yourself and the firm at risk, because you're doing different things each time in how you're performing your duties. So one question I had in all of this, as a firm, as a funding platform, but let's talk at it from a broker-dealer firm. What kind of regulatory requirements do they need to meet as to the type of people they retain? So are there any restrictions that the people undertaking the KYC with sensitive information, okay, like people's driver's license, date of birth, social security, do they need to be U.S. nationals? Does that need to reside in the United States to be done? I love to hear. I know I'm a little deviating a little bit from what, but it's not really, because I'm seeing something right now in the market, and I'm wondering, is this in line with what the intent was of FINRA, how our broker-dealer grows? Love to hear your comments on this, Mitch.
So, and I might need Marty to back me up on this. So it's a really great question. And I think it really comes down to a privacy and information security aspect as well, because, in terms of your privacy notice, whether it's employees or use of service providers, I think you would have the requirement of disclosing where those service providers that you may be using. And again, I know that the European privacy laws may be are more stringent than the US, especially with GDPR and all that other good stuff. But the long and the short of it is, from a pure FINRA perspective, let me start there. Anybody who you have accessing sensitive client information or sensitive PII, we can argue what requires registration in terms of roles and responsibilities, but at a minimum, those people should be non-registered fingerprinted or NRF'd with the firm. This way, at a minimum, they're fingerprinted and you've handled those requirements. Now, to the extent you're supervising a process, or you have access to the books and records around the process, we can argue whether you need a Series 24 from a supervisory principal perspective, or a minimum of a Series 99 if you have the ability to manipulate the books and records of the firm. Okay. So, but again, I only know as much as I know, but I would think I think the question is bigger, because if you're relying on service providers or contractors or employees who are outside the U.S., I don't know whether or not, from a legal perspective, that creates an issue, not a FINRA related issue, but some sort of a privacy related issue for the firm.
But it's interesting, because sometimes privacy is even bigger than FINRA, right?
Well, again, so the problem you have, especially when you are a multi-jurisdiction company and you're an integrated financial services firm, sometimes when you're fixing one thing, you're breaking two or three others. So you really have to look holistically at all those jurisdictional requirements and figure out how you live and breathe within those.
Interesting. Marty, did you want to put any comments on that?
Yeah, I think that Mitch nailed it. I think that there are a couple of things to think about. There's the privacy, there's security aspects to it, making sure that if to the extent they have access to personally identifiable information, that that you have the proper security measures in place. I think that's primary. And then if there are roles that they're providing that fall within licensing requirements, that they have those licenses. I mean, you're typically these, outside service providers will try to do everything they can to not fall within those licensing requirements. But I think that's important to note that. And you were talking about them being outside of these sort of non-US service providers. I think you just have to be extra careful on those matters, just because if nothing else, you're exposing yourself to a potential claim. I'm thinking about it I'm trying not to be like, hey, if they're not in the US that they aren't great, because that's not true at all. But I think you have to just, from a potential liability, to the extent, you want to make sure that
this is bigger than FINRA.
I was just going to say that this is bigger than FINRA. It's sort of like SEC says, hey, listen, if you're going to be the ambassador and say you're wonderful at this, just make sure you put your legal disclaimer you're getting paid. So as long as everybody knows, then nobody can. The thing here that's important is the broker-dealer is transacting with a company that is required to be US based. So let's just take this. These regulations, in particular Reg CF and RegA, require the companies to be domiciled in certain countries for a reason, right? And so on. And all of a sudden, you're using people outside of the United States, like the Philippines. This is where I'm now seeing a trend. And so that's okay from the firm. Yes, you did background checks on those people at the very least, and you've taken care of that. And there's a supervisory component. Fantastic, great. But you need to inform everybody down the line, right? So we had a situation where we detected through our AI detection that someone was using the compliance desk from a broker-dealer from outside of the United States and Asia. So our system automatically locked it out. It's just a way of protecting. We don't know if they got hacked or anything like that. So, we did our undertaking, and, they have staff over there. So the question then becomes, what are the responsibilities to the end user, which is the company and the investors? Are they aware that the information that they're providing, passport information and all that, are they aware that it's outside in a different country? I think you're right. I don't think this is FINRA issue. I think it falls, and FINRA pushes it off an issue. Make sure you're following privacy policy procedures based in the country in which the individuals are being managed. My last discussions I had with the SEC and FINRA not that long ago, about a year ago, was regarding about the investor information while the investor is making the investment process, and when a company outside of the United States is doing the marketing. In their view, they saw it as the responsibility as the broker-dealer. As long as the broker-dealer knows about it and they disclosed it, it's okay. So that was the only then, but they always had the premise, making sure that it's not our privacy, but they need to follow privacy laws. And I think that's an interesting one that none of them think about, right?
Well, you said something that's really interesting about, you saw an IP address from outside the United States, right?
Yes.
That's so it's a bigger IT security issue than that, right? Because yes, let's assume it's legit and you're using a service provider, the broker dealer has an employee wherever they have them outside the United States. But let's take it a step further. Let's say there's an IP address trying to hack into the client's instance of, to get into their investment or whatever. And, I've seen this so many times where, it, like, the access points where there should be those protections failed. Okay. And like, there was one particular instance I was involved in. It was an IP address that was like, really, when they figured out where it was, the location was the middle of Lake Michigan. And so like, you have to have these robust processes in place to identify that kind of stuff. But I think, I always recommend in these instances, it's really important from a legal jurisdictional standpoint to understand what your liability is. Again, outside the FINRA world, is from a privacy and information security standpoint to disclose where their data is going and who has access to that data, and whether or not that's enough or what else is needed, whether it needs to be positive consent, negative consent, I don't know. But the long and the short of it is, it's a great question. And I know with dealing with European companies, even if you say, well, all your data is stored in the cloud, but where are the servers? They want to go down to that level of detail. Yeah.
It's, we did it as a company. We needed to make sure that all the data was housed at a, FINRA and SEC compliant facility, which Amazon is, and making sure that it's US servers to protect. But just because the data is there, the entry points, we still need to protect that as well, right? But it is interesting that I think every company that operates, when they're operating online, they're cautious of two things: privacy laws, wherever they're interacting, and so on. But we need to remind broker-dealers and everybody else compliant in this space, not only do you need to follow the SEC and FINRA, you also need to follow privacy laws related to the parties because you're handling data. That data they're handling is the most precious part. That's why, I'll give you one example. We don't store credit cards. We don't collect it. We don't do anything. Why? Because you need to become PCI compliant. And people go, well, just go get it. Well, okay, you got $1 million. I'll go and do it. But why? Why do I want to become the credit card processors? The payment gateways already have that. And people go, oh, just getting credit card is no big deal. The penalties associated, this has nothing to do with FINRA or the SEC, are so high that you'll be out of business. You'll never be able to transact again because of it. So I think it's a good reminder. I know today we deviated a little bit, but I think it all came back to what the discussion was. How does a broker-dealer or anyone operate using RegA? Making sure, once again, we're just repeating ourselves, but I know repetition is the key to learning. Listening, reading it, and watching it to make sure that you do it properly. But the takeaways for me today from both of you, and I've written down big letters here, is creating a grid, and not just you doing it yourself. Work with Marty, work with Mitch's group to get that down and follow it. Right? Follow it. That's it. One thing is like, you put an action list on the board, but if you don't follow it, who cares? As the director of enforcement at the SEC is indicating, just because you had the policies and the procedures and you didn't follow it, you're still guilty for the activities you did. So I want to thank you both once again for an enjoyable conversation in bringing this to light. Next week, we're going to be back again, same time at 1:30 p.m. Eastern. The conversation is going to be, actually Mitch led into it, but we're going to really dig deep into the difference in KYC for RegA, RegCF, and RegD. We're going to really go into the nitty-gritty. We're not just going to sugarcoat it on top. You do this, because there is a lot of discrepancies in KYC, and we need to dive into it, and might as well learn from the experts. Hearing from there, the pros and cons either way. What are the red flags, that people need to be aware? Why is there so much discrepancies in ID and AML providers, and so on? And my favorite one, and this is for all the CCOs out there, just because you got someone's social security number and it comes out positive, it's not meaning that they passed KYC. So till next time, I want to thank Mitch and Marty, and I'll see you both here next week. Thank you again for your time, and thank you, everyone. Thank you.
Thanks
Oscar.
everyone. Bye-bye.
Bye.